Greetings from southern Germany. By now, many of you are aware of the July 2021 decision by the Michigan Supreme Court in the case of Paul Betts. Certainly the chat groups on Reddit are aware of it. I first became aware of it when one of my colleagues told me about it. He said that the Michigan Supreme Court had recently found that the Michigan Sex Offender Registry was unconstitutional. Well, that would certainly be a reason to pop a bottle of champagne. So when I went looking for it online, went looking for information, I found more than a few articles. But did the Michigan Supreme Court really throw out the state's registry in its entirety? You know me. I don't take most things at face value that I see on or read online. And something so wonderful as this, well, quite frankly, it seemed too good to be true. So recently, while I had a few days away from work during this short vacation with Justin, I pulled the Michigan Supreme Court's decision and read it for myself. It is rather interesting. On the one hand, I was disappointed to learn that the court did not throw out the registry wholesale. In fact, it didn't throw out any part of it. The Michigan Registry, along with its 2005 and 2011 amendments, is still in force today. However, on the other hand, the court did rule that the most restrictive terms and conditions of the registry, which were implemented through those 2005 and 2011 amendments, amounted to increased punishments. And as a result, they cannot be applied to any registrant whose conviction occurred before those amendments were enacted. The court went on to make some very important statements about the registry in general. Before we get into this analysis, let's very briefly brush up on our constitutional law and remind ourselves what we know about the ex post facto clause of the United States Constitution. In basic layman's terms, the ex post facto clause holds that once a person has been sentenced for a crime, his or her punishment cannot be increased or worsened in the future. For example, let's say that Mary has been convicted of public intoxication and sentenced to 1 year in county jail. She's already completed her sentence, gone through rehab, she's gone about her life. Let's say further that the legislature comes along a few years later and increases the penalty to public intoxication to include an additional $1,000 fine. The ex post facto clause prohibits the government from going back and adding the $1,000 to Mary's sentence. I mean, to do so would make her sentence harsher than it had been, right? That just wouldn't be fair. Now, if Mary were to relapse and get a hold of another bottle and get herself a fresh conviction for public intoxication after the new penalty went into effect, this time around, she would receive another year in jail and she would receive the $1,000 fine. This time around, she'll have to live with the harsher sentence. Paul Betts was convicted and sentenced for an offense in 1993. After he had begun serving his sentence in 1994, the legislature in Michigan created a restricted database available only to law enforcement officials of the names of persons convicted of sex-related crimes. Since that new database was not open to the public and did not make his sentence any harsher, there wasn't really a constitutional issue there. So Mr. Betts went on to finish his prison sentence and successfully completed his term of parole. He was finished. He was arguably a free man. However, in 2011, a full 17 years after his arrest and conviction, the legislature of Michigan amended the sex offender registry statutes to include restrictions on his freedom, such as forbidding him from living within 1,000 feet of a school, having to pay an annual registration fee, requiring that he report to law enforcement if he intends to travel, and so on. Effectively, these new restrictions on his freedom were added more than a decade after he had already completed his sentence, but really they were like being on parole again. The question became, did these new restrictions under the amended 2011 registry law make his original 1994 sentence harsher? Well, in 2012, Mr. Betts was arrested for violating some of those restrictions on his freedom, which had not been part of his 1994 sentence. Rightfully so, he challenged his 2012 convictions under these new registry amendments. Long but interesting story made short, the Michigan Supreme Court determined that yes, these new restrictions did in fact make his original sentence harsher. Effectively, imposing the 2011 amendments on anyone convicted before 2011 violates the ex post facto clause and is therefore unconstitutional. Now, here's where we must be very careful in interpreting this ruling. Contrary to what I have seen and read online, this ruling did not find the Michigan Sex Offender Registry itself to be unconstitutional for all persons convicted of sex-related crimes. Instead, it limited its ruling to finding that it was unconstitutional only when those new restrictions enacted in 2011 are applied to anyone who was convicted before that date. For anyone convicted after 2011, the registry restrictions remain in force. So to be clear, the registry was not thrown out, only a portion of it, for folks who were convicted before 2011. The registry itself is still in place. Anyway, I found that ruling to be rather interesting and thought that you might too. So hoping that this was informative and hoping that you're able to do something with this information, I'm going to give you my very best wishes for health and safety. Until next time, my friends, from a very beautiful summer in southern Germany, tschüss.